Everyone, and welcome to session 2. This session is all about knowing your loved one's rights and how to protect their rights and how to protect them from discrimination due to their disability. And we're also going to talk about accommodations they can ask for to get better care in the medical setting. So we have rights and responsibilities, and some rights are protected at the federal level, and some are at the state level, and some are by specific institutions. We also have responsibilities to get the most out of healthcare. Patients have to work together with their service providers. They do their part, but we also have to do our part. So basically what that means is sometimes we kind of have to ask for what we need. So here are some common patient rights. Being treated with dignity and respect, freedom from discrimination, a right to request accommodations based on disability status, a right to privacy and confidentiality, having a family member, friend, or advocate present to support you during medical care, and informed consent. We're going to talk more about all these rights in the coming slides, so you'll get to know all of these things really well. Here are some common patient responsibilities: to treat providers and staff with respect, to arrive on time for appointments, to use emergency services appropriately, to be truthful when we describe our experiences, behaviors, and medical history, to ask questions when we don't understand, to cooperate with treatment plans, and to be accountable for our choices and actions regarding our healthcare. And so just some things to think about, like what comes up to you when you read this list, what things might seem hard for you or your loved one, and whether or not this list feels manageable to you. Okay, and then this slide, we're going to talk about Section 504. So 504 is part of the Rehabilitation Act, which is another federal law. Section 504 was passed in 1973, and it was the first federal law to recognize disability as a civil rights category. So it created a protected class for disability status. And the law protects qualified individuals from discrimination based on disability, and it applies to employers, organizations that receive federal funding. And this includes many hospitals, medical centers, mental health centers, and human service programs. Sometimes we gain new rights according to the law, but it takes time for institutions to change their policies and start respecting those rights. However, through advocacy, both individually and in partnership with other people, we can put pressure on institutions to change faster and respect our rights now. One good example of advocacy leading to the implementation of disability rights happened during the early years after Section 504 became law. Even though it was law and it was passed in 1973, it was rarely enforced in the first few years after it was passed. By 1977, the disability community was tired of waiting for their rights to be recognized. So activists organized sit-ins in cities all over the country. In San Francisco, more than 100 disability activists and their supporters took over a federal building and stayed for 26 days, only leaving once their demands had finally been met. And this is part of the documentary that we talked about last time that we mentioned, called The Crip Camp, which I believe is still on Netflix. And these were known as the 504 sit-ins, and they were protests were successful at creating a path from rights recognition to implementation. And these also paved the way for what we know today as the ADA. So this is a really amazing story, and we don't have time to delve into all the things that this advocacy work brought to us and how we got to where we are today with the ADA. But there's a lot of cross collaboration between all disability categories. Black Panthers were there to support people with disabilities. It's a really cool thing to check out and definitely something worth looking into on your own time. And now we have the ADA, which most of us are probably at least familiar with hearing that term and some of the parts of it. And that stands for the Americans with Disability Act. And the ADA was signed into law in July 26, 1990. And at the time it was signed in, it had historic support from both sides of the aisle. So the Americans with Disability Act was the world's first comprehensive civil rights law protecting people with disabilities from discrimination. The purpose of the law is to make sure that people with disabilities have the same rights and opportunities as people without disabilities. And you can see people who actually got out of their wheelchairs to climb up the steps of the Capitol to show that it was not accessible to them. This bill is pretty straightforward at the highest level. Of course, there are lots and lots of specific requirements when you dig into the actual text of the law, but for our purposes, the major distinction is that with the ADA, protects people with disabilities from discrimination in all areas of life, both public and private. So the ADA expands on the protections covered by 504, which just covered employers and federally funded institutions. It covers federal, state, local governments and institutions, as well as private businesses and nonprofit organizations, whether they receive federal funding or not. If you have the workbook that is linked under these videos, there's some additional information about how the law defines disability. And the image on the slide is just a picture of a really cool protest that happened leading up to the passage of the ADA, and it was called the Capitol Crawl. During the protest, disability activists abandoned their wheelchairs and their mobility aids and started crawling up the US Capitol, and they were just demonstrating how inaccessible this building was. But it was also a symbol about the inaccessibility of all the institutions that the government was representing by not passing this law. And now we're going to talk about the Olmstead decision. The Olmstead decision is really important for people with IDD because it means that they have the right to live in the community or at home with their family instead of the hospital or institution. Sometimes you'll hear people refer to this as least restrictive environment. You hear that a lot in schools when you're attending IEP meetings. And often they will also, in adult services world, they'll also use that term to basically describe where is the person receiving the best care without restricting their environment to an institution. So there's some background on this. On June 22nd, 1999, the US Supreme Court reached a decision in a case called Olmstead versus LC. This case became known as the Olmstead decision. The case involves two women who had IDD and who also struggled with their mental health, Lois Carter and Elaine Wilson. Separately, Lois and Elaine chose to check themselves into a state hospital in Georgia, where they each received treatment for their mental health. When their treatment was finished, mental health professionals agreed that both women were stable and could transition to community-based treatment. However, the state of Georgia didn't have an appropriate program available that could support Lois and Elaine, and the state didn't think it was safe for the women to live independently without support. Because of that, the state said Lois and Elaine needed to stay in the hospital. Lois and Elaine sued the state of Georgia, saying their rights had been violated according to the ADA. Eventually, their case went all the way to the Supreme Court. And after years of legal battles, the Supreme Court ruled that the state doesn't have the right to keep people with disabilities in institutions. Instead, states are required to provide services that allow people with IDD and other disabilities to live in the community if that's what they prefer, and if their treatment professionals agree it's appropriate. And so we are kind of seeing some of this reflected in the state of Maine currently. There's been I think in 2019 or maybe in the beginning of 2020, there was a lawsuit brought against DHHS in Maine and trying to make those services more appropriate for people, because particularly with people with chronic and significant medical disability, a lot of their options, because of the lack of services here in the state, are to go into nursing homes or long-term care facilities. And so they are working on making that better, and that is on the radar in our state of Maine. And if you check out your workbooks, there's some links to some websites where you can learn more about this court ruling. And in 2006, the United Nations had a convention on the rights of persons with disabilities, and they adopted an international human rights treaty to protect the rights and dignity of people with disabilities. The full name of the treaty is the Convention on the Rights of Persons with Disabilities, or the CRPD. Countries who ratify the treaty commit to promote, protect, and ensure equality under the law for people with disabilities in their countries. The CRPD is important because even though it's an agreement between nations and not an enforceable law, it demonstrates how the disability rights movement has become a global movement. At the time the treaty was originally completed in 2006, 82 countries signed the agreement on opening day, which is the very first opportunity a country has to ratify a new treaty. At that time, it was the highest number of signatories in history for an opening day treaty. almost 20 years later, as of March of 2024, 164 countries out of the 193 UN member states have signed the treaty. The United States is actually one of the handful of countries that has not ratified the treaty. However, the CRPD was inspired in part by the passing of the Americans with Disability Act, and many of the protections outlined in the treaty are already law in the United States. Even so, Americans with disabilities continue to put pressure on Congress to join the majority of nations in ratifying the CRPD. And there's links in your workbook to the UN website, and you can learn more about the convention. And they also have some really great data on health disparities and health challenges that people with IDD face and disabilities in general face across the globe. So what does this all mean? Section 504, the ADA, and healthcare. Section 504 and the ADA reinforce similar protections in a healthcare setting. Basically, these laws make sure that people with disabilities have full and equal access to healthcare services. Sometimes to get a full equal access, a healthcare organization will need to change one of their policies or procedures if it's set up in a way that doesn't work for people with disabilities. And those changes are called reasonable modifications, which we'll talk about more on the next slide. Healthcare organizations and facilities also have to think about how they communicate and make sure they have different communication options based on a different person's needs. And finally, their facilities need to be accessible. So reasonable modifications, and what are they? In a healthcare setting, reasonable modifications are changes to policies, practices, and procedures that allow a person to have equal access to healthcare facilities and services. These are also often referred to as accommodations. At the bottom of the slide, you can see some images that represent different types of accommodations. So you can see like the service dog picture, the ramp, a sign language interpreter, extra time at an appointment, a language interpreter for something other than English, Braille. So these are all accommodations that healthcare settings has to make based on your needs. We're going to talk a little bit more about those. So there are lots of different types of accommodations, and it can be helpful to group them into different categories. For example, physical accommodations like ramps, making sure elevators are working instead of stairs, wider doorways, accessible bathrooms, and lifts for exam tables. You can also have sensory accommodations like chemical-free spaces. So sometimes if you've ever been into a doctor's office or a specialty's office and it says like no smells and no scents, that can be a sensory accommodation for patients. Low lighting, or requesting that specific materials are or are not used during exams. So some people really dislike those paper rollouts that go across an exam table, that it's just sensory wise they can't handle it. So that might be an accommodation you ask is, can I have the paper removed? And they would have to sanitize the table differently that day. There's also something called the time accommodations, and that's something, for example, like asking for a longer appointment time. Many standard medical consultations are scheduled for only 15 to 20 minutes, which if you have a processing delay or you have any type of communication issue, 15 to 20 minutes is just not enough time for you. And so you can ask, based on the nature of your disability status, to have a longer appointment time, and they do have to accommodate that. You can also have communication accommodations, like using a communication device, like an AAC device, or storyboards or pictures, asking for things to be explained in plain language without medical terminology, asking to communicate by email instead of phone, or phone instead of email. And finally, support accommodations, like having another person in the exam room with you or bringing a service animal. And there's some more detailed examples of this in your workbook as well. Just like people, accommodations can be very unique. So it could be something that you'd never thought of, and that is what your person needs to get through the appointment, and that can happen. And at the very end of the section in your workbook, there are some specific examples that kind of illustrate this further. So what happens when accommodations are denied? Sometimes your loved one might ask for an accommodation that a provider is unable or unwilling to provide. Because providers are only legally required to provide reasonable modifications, sometimes people disagree about what types of changes are considered reasonable. If that happens, it can feel really frustrating. And so if this happens to your loved one, they have a few options. First, they can ask for an explanation. Sometimes through conversations, it's possible to negotiate an acceptable compromise. If your loved one can't find common ground with their provider, they can ask to speak to someone else and try to get their needs met in another way. Depending on the facility, they may ask and be able to speak to a disability access coordinator, a civil rights liaison, an ADA coordinator, your local protection and advocacy agency. So that, for an example of that would be Disability Rights Maine or a patient advocate. And there are some links in the workbook to find local representatives in Maine. And finally, if you try all these options and it still feels like their disability related needs are not being met, then you can file a complaint with the ADA. So just take a moment before we move on to think about and reflect on the accommodations that you think your loved one might need to receive full and equal access to healthcare. And there's a place in your workbook, if you have it printed out, or if you just want to jot this down in a notebook, some notes and some questions you might want to ask to your provider to see if you can make these accommodations happen more frequently. Just take a minute to think about that and write. Okay. So one of the things that is uh, brought up a lot about HIPAA is what is HIPAA and what is not HIPAA. And so just one thing to remember is when you're giving your information to um, an outside organization that's not a medical organization. So for example, if you participate in Special Olympic sports, you share some basic medical information for, in case of an emergency or things like that. We're actually not a HIPAA protected organization because you're choosing to share that information with us. Obviously, that information is being held safely, and organizations are hopefully not using that incorrectly, but that is something that I think sometimes people have a misunderstanding about, is that when you are disclosing that information yourself or on behalf of your loved one, you are not protected by HIPAA at that time. All right, so we are going to watch another little video that talks more about sharing health information. And this one will talk about the types of support you can get from family and friends, so that it's going to be really important to talk to folks who are caregivers. So we just heard that HIPAA requires healthcare providers to protect the privacy of each person's health information. However, if the person receiving care doesn't object, a provider may share relevant information with family members or friends involved in the patient's care. So we're going to watch a video to learn more about that. And I am going to have to, I don't think this one will work either, but we'll try. No? Okay, so we are going to watch this one on YouTube as well. Let me just pull that up real quick. Okay. Okay. Go back to the PowerPoint one more time. Okay, so I want to highlight the important point from that video. It said that in some cases, the patient needs to give permission for their health information to be shared with someone else. But in other cases, health information can be shared so long as the patient doesn't object. So for some of you who might be helping to care for someone who is more impacted or less likely to have the tools to communicate with their health providers on their own, this means that the health provider can use their judgment and share information directly with you in front of your child or loved one, as long as they don't tell the provider to stop. So one thing we're going to talk about now is self-determination. And people with IDD have the right to determination, which means they have the right to make important choices that affect their life and their future. Sometimes people with IDD need support in making these choices, just like people without disabilities. So everybody needs support at times, not just people with disabilities. We may ask for advice from people we trust or do research online, but our decisions are still ours to make. That's self-determination. We get to determine the course of our lives. When you help care for someone with IDD, it's important to support them to make their own decisions whenever possible instead of making decisions for them. You can also help make sure other people in their life don't make decisions for them either, no matter how well-meaning that person's intentions are. And so one thing I mentioned as a former teacher is we had a student who really liked to wear mismatching like shirts and pants combos that personally I wouldn't have chosen myself. And sometimes people would make comments like, well, why don't you show them or make them wear something different that's more matching? And my comment was, we've given them that option and this is what they've chosen to wear. And that's their right as a human being to choose what they want to wear. So that's just like a simple example of that, that self-determination and fostering that in someone. And another thing that kind of goes with self-determination is supported decision-making. And so here in the state of Maine, we have different levels of guardianship, and one of those levels is supported decision-making. And supported decision-making allows people with disabilities to make choices about their own lives with the support from a team of people that they choose. So, and this is an alternative to guardianship. So sometimes people with IDD need help making decisions, but that doesn't mean that their right to make their own decision should be taken away. And there's a movement that's been growing away from guardianship and towards supported decision-making. If an adult with IDD needs help making the kinds of decisions that will keep them safe, it's been somewhat common for family members to seek guardianship of that person. And what guardianship means is that you have full control over that person's life, financial, medical, day-to-day living. And in some cases in the state of Maine, we do have levels of guardianship. So you can choose to be someone's financial guardian or someone's medical guardian and give them independence in other areas. But we also have supported decision making here. And when you have full guardianship of a person, of course, that's because we want to protect the people we love and keep them safe. And so we can understand why a parent or adult sibling would try to get guardianship over your loved one even after they turn 18. But actually, there's another option, and it doesn't have to be one or the other, where someone makes either or all the decisions or none. It can be a spectrum. And this is where supported decision making comes into. So there's full autonomous decision making. The person can make the decision all completely by themselves. And then there's fully substituted decision making, which is guardianship. And so again, using that term least restrictive, we're trying to create the least restrictive environment for someone to make for safe decision making. Okay, so going over our fancy graphic, let's kind of make sense of it. Over on the far left, we have the person in green who can make decisions completely on their own. And on the far right, we have two orange people, and the smaller orange person in the background isn't legally allowed to make any important decisions on their own. Instead, their guardian, who is standing in front of them, is in charge of making decisions for them. The green arrow points to the person on the left, and they pave the way to our goal. We want to create the least restrictive, safe decision-making environment. The more each person can be supported to make decisions on their own, the better. In the middle of the graphic, we have some arrows pointing to the spectrum, and it says assessments of needs and capacity. This means that before we just make a decision for someone, we want to ask ourselves if they really need our help or if they have the capacity to make that decision more independently. And every type of decision is different, and some might require support while others don't. Some types of decisions will fall somewhere closer to the green side of the spectrum, and some decisions will be closer to the orange side. The whole process is called supported decision making. It is an alternative to guardianship because it allows people to get support with some decisions and to make other decisions on their own. For example, some people with IDD might be able to cook basic meals and live independently, but they might need support managing their bills or knowing what type of social media interactions are appropriate. A caregiver can back way off on making decisions about meal planning or how this person decorates their home or spends their free time, but the caregiver might want to offer more support with money management and modeling appropriate social behavior. Thinking of decision-making as a spectrum allows us to approach each new decision with curiosity and an open mind, and protecting the dignity and self-determination of people with IDD. If you want to create your own supported decision-making agreement, the American Civil Liberties Union has a template you can use, and it's linked to our workbook. And really at the heart of supported decision-making is person-centered planning. So here in the state, typically we talk a lot about person-centered planning in the transition process out of high school into adult life. And that applies to supported decision making as well. We want the person to have a team of trusted individuals that they can go to help make these decisions. And that can be family, that can be friends, that can be some other stakeholders in the person's care. But it also gives them that feeling of autonomous decision making as well. So informed consent. A patient must be appropriately informed before they can give consent to undergo treatment or receive medical care. Why is it so important for us to have clear decision-making plan before we support someone in receiving medical care? Because healthcare providers like doctors and dentists are required to get this informed consent before they can provide treatment. So what does that mean? Informed consent means that a patient must be appropriately informed before they can give consent to undergo a treatment. In other words, the provider is responsible for giving information and making recommendations to the patient based on their professional expertise. And then the patient gets to ask questions and has a chance to learn about the risks. Once the patient understands what is being proposed, the patient has to say yes to moving forward with the procedure or treatment, and this is the process of confirmed consent. Whenever possible, the person receiving the treatment should be the one to decide if they are okay with a treatment plan. And as we discussed on the previous slides, it's okay if they get support making their decision from people they choose. A health passport is a booklet that you can fill out and bring to each of your medical appointments. You can also email it to your provider for them to review before you arrive. So it's just a tool to help you stay organized and help get your needs met. And by taking the time to fill out a health passport before you visit with a provider, you'll feel more organized and more prepared to ask for any necessary accommodations. In your workbook, there's a list of several health passports designed with the needs of people with IDD in mind. For today, we're going to go through just one of them together so that you can get a sense of what to expect. And then later you can check out the other ones and see if they make more sense to you for you and your loved one. You can also make your own or adapt something that you already use. So here's some example pages from the My Health Matters Health Passport, which is from Australia. But like I said, you might decide to use a different health passport. You might like it better. Some people want to fill out a few sections, but not others, so you can kind of use it as you feel fit. A health passport is going to contain information about the user's medical history, their disability status, accommodations, communication needs, consent, procedures, and more. And this can also help if there are multiple caregivers in your loved one's life. So that it can help the caregivers continue to support decisions that loved one is making by having all this information readily accessible to them. So here's an activity you can do on your own time. You can review all the sections, pause and reflect before filling out any of the information, and make sure you know the answers. Or do you just think you know? Is it something that you would best be sitting down with your loved one to fill out together and make a final draft of? And so your homework for this session is to pick a health passport or create your own version, or pick apart one that you feel like works for you. And I invite you to, together with the person that you help care for, to complete or edit one of the health passports that are linked in the workbook. And this is just another tool to make your life easier, not harder. So if filling it out really detailed is not your thing, don't do it. If it's sitting down and doing that front loading work of having a really detailed passport is you find might be helpful for you and your loved one, definitely take the time to do so. Like I said, it's something that your loved one can keep with them, so that no matter who they're with, they can kind of navigate their healthcare system on their own. Um, so thank you all for this session, and next time we're going to go over supporting self-advocacy.